There it is. Gorgeous. No, not the agenda, but something else. Good morning, everybody. Welcome to Senate Economic Development, Housing and General Affairs. Good to have you back. Today is Thursday, so we're pivoting to labor. And then later this morning, we're going to pivot to workforce and hear from a combination of workforce and economic development in our outdoor recreation space. That's later this morning. But right now, we are going to turn to two bills, which seem to be the bills that we're going to coalesce our labor work around for this first part of the session. And unfortunately, Perry Brown, who was going to really give us an in-depth update on the flexible work world, is unable to join us this morning. Carrie, we hope everything is well. And so, actually, in a surprise move, we're going to begin with Megan Sullivan.
Some credit for everyone involved.
And if that is too much, we are so flexible in this room. We are also happy to pivot. And she is ready for the moment. Right. Welcome.
Thank you. For the record, Megan Sullivan, Vice President of Government.
Yeah, and we're just going to start with S230, which is the flexible.
The only thing I was prepared to talk about.
Yes, that's right. And I just want to update the committee on 173. The House is actually.
All right, I don't do the numbers.
That is the Workers' Comp and Labor Relations Board. The House is actually moving on the Labor Relations Board work, and so we're going to strip that out of our 173 and just do the Workers' Comp piece, because they're moving a bill. So, Megan, welcome. And we are going to talk about flexible work. Carrie is so she's my favorite.
Okay. And happy outdoor recreation.
Yes, and happy outdoor recreation. Yep, and we're joining them for a piece, and they're going to testify specifically on this stuff that's in our bill.
This afternoon at the legislature, I'd like to just take the afternoon off so we can all go to cross country ski and do any outdoor recreation. So it'd be totally on board with that. But that doesn't affect this chair. No. All right.
I've never know a cross country skiing. Are you kidding?
All right.
Did you bring us skis and snow pants and all the rest of it?
Maybe the outdoor rec folks did.
Okay. Okay, welcome, and let's talk about this proposal.
Appreciate the opportunity to testify on SB 20 and the committee's continued focus on workforce issues, and the role workforce flexibility can play in employee retention and job quality. Employee retention, employee recruitment is obviously something that we and our members are incredibly focused on, given the challenges to our demographics and even the most latest news that we've lost 1,800 more people in our population in the state. We do have concerns after we've reviewed S220 as drafted. 230.
230.
Our concerns are not ideological. They're grounded in how the current law already operates, what the enforcement data shows, and whether the proposed expansion is proportional to any demonstrated problem. So Vermont's law is already extensive. We have one of the most comprehensive flexible working arrangement statutes in the country. Under 21 VSA, State Statute 309, employees have the right to request intermediate or long-term changes to hours, schedules, or work location, and employees are required to consider those requests at least twice per calendar year, engage in good faith discussion with the employee, evaluate whether a request can be accommodated without being inconsistent to business operations or contractual obligations, provide a written response when requests are made in writing, and refrain from retaliation. The statute also explicitly identifies legitimate business reasons that may justify denial, including cost, staffing constraints, service delivery impacts, morale, performance, or the inability to reorganize work. What the current law intentionally does not require is an employer to grant requests regardless of operation realities. It guarantees process, transparency, and protection from retaliation while preserving flexibility for businesses operating in very different environments. Enforcement data does not show a systematic problem. When evaluating legislation, this committee routinely and appropriately asks, what is the problem this bill is trying to solve and where is the data? That question is important here. The Attorney General Civil Rights Unit, who I connected with about what they were hearing in terms of complaints where the laws exist, said that the complaints alleging violations to state statute 309 have been exceedingly rare since the law took effect in 2014. Over the past 12 years, the Civil Rights Unit estimates that it has received roughly a dozen complaints that included an alleged state statute 309 budget violation. And it should be clear that those were not standalone complaints, they were part of broader complaints.
And may I just ask, I will maybe get the AG in on this. Do you know how many were acted on?
Approximately half were resolved without formal investigation. The remaining matters proceeded into investigation only because they involve separate and independent claims under other employment laws, such as disability discrimination or family medical leave violations. The Attorney General's office could not identify any formal investigation focused solely on state statute 309, and the state has never pursued a court action alleging a violation of the flexible working arrangement statute. For context, during the same period, the Civil Rights Unit has handled hundreds of investigations, hundreds more complaints involving other employment statutes. If this were a widespread or systematic problem with employers ignoring or abusing flexible work requests, we would expect to see that reflected in complaints or enforcement activity. The available data does not support that conclusion. This is a significant policy shift without evidence of need. S230 would materially change the structure of Vermont's flexible work arrangements law. Under current statute, employers are required to consider requests, engage in good faith discussion, and respond. Employers must show they followed the process, but they retain discretion to deny requests for legitimate operational reasons. S230 would convert that framework into presumption of approval. Employers would be the ones required to grant the requested flexible working arrangement unless they could affirmatively demonstrate that doing so is inconsistent with business operations. This shift has practical consequences. First, it changes the burden of proof. Under current law, employers must show they considered a request. Under S230, employers would need to justify and defend denials, increasing the need for documentation, internal analysis, and legal review, particularly where operational impacts are nuanced rather than absolute. Second, it meaningfully increases administrative workload. Employers would need to evaluate each request against statutory criteria, document operational impacts in anticipation of potential challenge, and ensure consistency across employees and departments to avoid disparate treatment claims, potentially revisit prior approvals as business conditions change. For a mid-sized employer, that could translate into hundreds of individualized terminations each year, each carrying greater compliance and legal risk rather than what's under current law, even when no enforcement or complaint action has occurred. The time spent reviewing, documenting, and managing these requests is real. For small employers, the potential increased uncertainty and risk where there is likely in-house HR or legal staff. Many operational concerns such as team coverage, customer service continuity, supervision, or workflow do not lend themselves to bright line rules. Requiring employers to defend those judgments as a legal standard rather than as a management decision creates ambiguity well beyond the current statute. Absent evidence that the existing framework is failing employees in a systematic way, expanding employer obligations in this manner raises concerns about proportionality and unintended consequences. Vermont is already a national outlier. Only 2 states, Vermont and New Hampshire, have broad statewide statutes requiring private employers to formally consider flexible work arrangement requests. Most states don't have this requirement, and there's no federal private sector right to request flexible work. Vermont already stands apart nationally. S230 would move the state even further from the mainstream by converting a right to request framework into something approaching a right to receive, without evidence that such a shift is necessary.
That's an interesting right to request versus right to receive.
I think context also matters. This proposal appears, at least in part, to be responding to recent disagreements between state employees and the administration over return to work policies. Vermont already has clear and established mechanisms for resolving those disparities in collective bargaining. Current law explicitly recognizes legal and contractual obligations. It does not override union agreements and scheduling, work location, flexibility in unionized workplaces, and that are appropriately addressed through negotiations. If the underlying concern has been brought up because of a specific public sector labor dispute, it raises a policy question about whether it is appropriate to impose new statewide mandates on private employees, particularly when no similar pattern of conflict or non-compliance has been documented in the private sector. This committee consistently and appropriately asks for data, outcomes, and evidence of need when evaluating proposals. And we looked into those standards when evaluating this proposal. Applying that lens here, Vermont already has one of the most extensive flexible work arrangement laws in the country. Complaint and enforcement data does not show systemic problem. Yet S-230 would add new substantive obligations on employers. As the committee considers whether to impose additional regulatory requirements, it's also important to keep Vermont's broader competitiveness context in mind. The Vermont Futures Project Competitiveness Dashboard shows that Vermont ranks 43rd out of 50 on a regulatory freedom index in the nation, with the dashboard noting that Vermont's fiscal and regulatory policies are among the most restrictive in the nation. When a state is already operating in a highly restrictive regulatory environment, new mandates should be grounded in clear evidence of need and demonstrable return. In this case, we have not seen evidence that supports that. Adding regulatory burden without data to justify it risks further eroding Vermont's competitiveness at a time when the state will be supported. That's the end of my written statement, which I will make sure to send it to Kiara.
Thank you. And just and make a note, we also originally had Beth Vestigi, our commissioner of our HR department in state government. And as you all are aware, the flexible work and the return to work issue is in front of the labor report board. It may go to court. It has been to court. It will go.
Well,
it
I
is
think
at the labor
similarly with
board.
the Attorney General's office. I don't want
Right.
to speak for them, but I think they would be in a similar situation at this point.
And so the administration asked that we not have Beth testify. The same is true. VSEA was going to testify, and they are also not testifying today as a result of that. So there is ongoing action in this arena for state employees. But this, as you have noted, is for all employers.
Right.
And you had a data point that I was not aware of, which is that Vermont and New Hampshire are the only two states in the country that have
From my
addressed
research,
this.
that is what I found, that Vermont and New Hampshire, what we have in place already is the only. There are states with predictive scheduling laws, but in terms of flexible work arrangements, what I found is only Vermont and New Hampshire.
Well, after COVID, that is a little surprising, and it's interesting. Thank you. Many, do you have any questions, David?
Yeah, I do have a question. So we have this draft 1.1.
Yeah.
How the bill was introduced. But the draft doesn't even contain the flexible working arrangement section. I'm wondering what the bill really looks like now.
Sorry, now that we're what?
I have to bring it up too. It's that really short bill that Senator Hirschlick introduced that would basically switch it to a shall. Do you have a copy of S-230? Is that what you're asking for?
I thought this was.
I have it. It doesn't look anything like draft 1.1. In fact, 1.1 doesn't even have the section about flexible working arrangements inside it.
I may have printed the wrong draft back.
No, 1.1 is in fact what we're going to be discussing next, because we've had two requests for us to review. And these are additional amendments for us to look at, David. They,
So
1.1.
this 1.1 is supposed to fit into the bills introduced.
1.1 is for us to consider, and you're going to hear from Colin and you're going to hear from Charlie. Both of them are here. The network has a request, and the VNEA has a request and this was this bill, as it was initially drafted, it had enough relation that this was the best one for us to consider these two proposals.
Okay. I have not seen those, so I don't.
Yeah, no, nobody, I mean, we're looking at them fresh today. Tom, Keisha, any questions?
No.
No, okay. Thank you. Have you sent that to Kiara?
That's what I was going to do while Terry was testifying. So now that's what I'm going to do next.
Thank you very much, because we would love to have that.
Yeah.
Much appreciated. And So, I think then we will shift, as David has noted, you have draft 1.1, I believe, at your place, which has two recommendations for amendment to S-230, and we could just use S-230 for these as vehicles if we want, and we'll obviously, we're gonna have a committee discussion on flexible work arrangements. But why don't we begin? I think the first one is Colin. Colin?
That is my name.
No, I know. But I think you're
Subject matter?
they're the full-time teacher. Oh, it's Colin, come join us.
Great.
Tell us.
And my colleague Rebecca McBroom's gonna.
Hello, Rebecca. You're welcome to join Colin if you would like. So, we are happy to entertain, so tell us what the problem is you're solving and why we're looking at this and how we can help.
Sure. So first of all, for the record, Colin Robinson, Vermont NEA. Good to see folks. We prepared very brief comments, nothing written, for the original time constraints that were for your committee.
Yes, but what's your shift?
I understand that. So
We appreciate an understanding of the problem.
yeah. So the context for the language, and I believe legislative council kind of walked you through it in a little bit. Last year, you'll remember that this committee worked on some adjustments to Vermont's unpaid family leave law in the form of H 461, that's now Act 32. And last April, your committee took some testimony from the Pilots and Flight Attendants Association around sort of an inconsistency that exists between the presumption of full-time work that exists for pilots and flight attendants for being able to access leave benefits that are available under state statute. And you remedy that. You said, okay, for purposes of flight attendants and airline pilots, let's cite federal regulation that says these workers are presumed to meet the minimum standard if they're full-time workers to make them eligible to access this.
The federal,
leave.
the federal.
Yeah. So the language you all moved forward last year and integrated into the bill had a specific federal regulatory citation for airline pilots and flight attendants. What we're asking for today is to say, well, if it was good enough for them, a similar presumption exists in federal regulations for school teachers. And it's the exact same construct. And so we believe that this was sort of we were doing a remedy last year in one particular space, and through just by virtue of circumstance, we find ourselves in a place where we're looking to have a consistent and parallel remedy for public school teachers as well. Again, if it was appropriate for pilots and flight attendants, seems like it should be appropriate. And the federal regulations are consistent in that matter. They are the same in so much as that presumption exists. So the language that a legislative council will be speaking to purely sort of says, here's the citation for airline pilots and flight attendants, and here's the federal regulatory citation for school teachers. So that's the headline.
And introduce yourself for the record.
Rebecca McBroom, General Counsel, Vermont NEA. I would add that most of the Vermont Parental Family Leave Act mirrors the Family Medical Leave Act. It was drafted as that sort of being the baseline. So I think that this makes sense. It exists under federal law. It exists under Vermont law as well. It's just paralleling the federal statute. And certainly I would think that if teachers are eligible for this under the federal law, we want them also eligible under Vermont law. So it's just, I think, really making the Vermont Leave Act consistent with the federal FMLA. It's not much more than that.
I guess I'm just curious, you have such a strong contract, the NEA teachers have such a strong contract. Is paid leave not a piece of your contract?
Well, we have a variety of contracts across the state.
Right, I
And
mean-
in areas where it's covered by either the state law or federal law, our contracts can add an addition to that, whatever that baseline is, but usually, you know, the Family Leave Act or the Vermont Parental and Family Leave Act is sort of separate and apart from those contracts, so that's the baseline.
That's, I think, a question people might have.
Yeah.
And then the other question is, given the governor's volunteer paid leave program, had the NEA thought at all to join that as a group, boosting those numbers? And I mean, I'm just curious. We have
the
the
short
documents in front of
answer,
us. I'm just curious.
the short answer is, to the best of my knowledge, that's not been brought up by either our members or school management officials in the course of contract negotiations. I don't know if that's for any particular reason. I don't know that it's for
Yeah,
our purposes. And so, yeah.
Right, but this exists already in federal statute,
Right.
and all we have to do is adopt it. I mean, we just have to change our statute to parallel it. Is that correct?
And the issue here really is this, there's a minimum amount of hours to be eligible to qualify. Of course, teachers, you know, work in excess, are salaried employees, they work very long hours during the school year. And then the question becomes this number of hours provision that exists under the federal law. It's the Vermont law.
How do the summer hours affect this full-time consideration?
Well, that's what's difficult. I think that's why
Yeah,
it
I
exists in Vermont laws, because our teachers are working far in excess typically of their normal workday. They're working weekends, working after school. And so the question is how to calculate that. That's why this carve-out's been made under federal laws, because it's hard to calculate for salaried employees that have that furloughed time during the summer.
Got it, yeah. Committee, any questions?
Are flight attendants, salaried, hourly workers, and pilots?
The short answer is I don't represent them, so I'm not familiar. I believe,
So
pilots are, I believe, salaried. And obviously I saw testimony that you all received from their union last year on this issue. And I haven't had a chance to fully review it,
I'm
but
just trying to say, you're making a comparison between what's in federal law relating to class of people, so I'm just interested in
Yeah.
what the other class of people that are
and maybe,
like this,
That's
some
my
people
understanding.
are they any different than teachers?
my understanding is that, I'm not sure about flight attendants, but my understanding is pilots. Others might be able to speak to that more accurately.
Sophie may have an answer. She's always and knows so much on this particular area. Great. If we have no questions, I'm going to pivot then to this. Should we, let's have Charlie, if you make your pitch as well. Pitch day here. And then we'll have Sophie up to talk about.
Great.
Is that okay?
Yeah, and we'll stick around. Happy to.
Oh, I would hope you would.
answer questions. Thank you.
And Charlie, welcome.
Thank you. Good morning.
Please enter the chair for.
Thank you for the opportunity to testify. Charlie Glesserman, Policy Director at the Vermont Network Against Domestic and Sexual Violence, and make my pitch today, aligning documentation requirements with our state leave statute that y'all did such a wonderful job advancing last year with Fair Employment Practices Act. So as you may remember in H461, which was our safe leave law.
We don't have this in front of us. We don't have your draft of this in front of us.
Or you speak to the
We have one
draft.
point.
That's 2:30.
I am. Sophie has some.
No, okay, we're just gonna wait. I mean, present, but guys, we don't have this in front of us. It'll come in 1 second. Oh.
Perfect.
Sophie and Karen, what a team. Okay, we now have it in front of us and that's okay. 1.2 is what we're working off of. Which we have columns and then now we've added
Thank you very
Sophie's under the I believe, second amendment on the bottom of page 1. Okay, so sorry, Charlie, take it away.
Terrific, no apology needed. So, last year, this committee advanced a bill, as Colin noted, 8461, creates up to 12 weeks of unpaid job protected leave for survivors of domestic violence, sexual assault, and stalking. They can seek safety, seek justice, and heal. In reviewing that statute, the Civil Rights Unit in the Vermont Attorney General's office identified a disparity between the documentation requirements needed to access safe leave and those needed to access protections against under the Fair Employment Practices Act as a victim of crime. The Fair Employment Practices Act prohibits employment discrimination based on protected statuses, and that includes status as a victim of crime. So this lack of alignment between the statutes could leave survivors vulnerable to adverse employment actions after taking their legally authorized safe leave because those documentation standards are not aligned. So we would request that the committee consider adding the language included in this latest draft to ensure that survivors can access both protections without unintended barriers and not fall into that trap. Thank you so much for the opportunity and time, and I would be happy to answer any questions.
So the AG's office noted that we had failed to include this piece of it, and so we'll have them in, obviously. Have we, in terms of the data on this, do we know how many survivors have taken advantage of the opportunities they already have in law, and do you have a notion of how many additional ones this would help serve?
I do not know, but I think the Civil Rights Unit might be better positioned to share their experience on that question.
Okay. So this, great. Any questions, committee?
Self-attestation, second on page 3. Paragraph 4. Does that mean that person who there's been no law enforcement report, there's been no court action, there's been nothing except the person comes in and says, I've been stalked or I've been harassed?
In short, that is correct. A person provides a statement outlining why what happened to them meets the definitions included in the statute. So say there are statutory references for domestic violence, sexual assault, and stalking. Within this statute, they would know what the harm that they experienced aligns with the description of the harm outlined in that statute, and that would be their self-attestation statement. And so they would still need to meet the what's the exact word? I guess barrier of outlining how their the threshold outlined in the statutory requirements here. So what they experience, say, as an instance of domestic violence, would still need to meet the threshold of domestic violence in 15 VSA 1151. And that doesn't change because their documentation is self-attestation.
Dave.
Okay.
No, after you.
Precedent for self-attestation.
I recalled when the committee was taking a look at H461 that there were other states that use self-attestation as a documentation requirement to access safe leave.
Precedent.
This would align Fair Employment Practices Act documentation with existing safe leave documentation requirements. So I guess that is a precedent, but this is language exactly that you all passed last year. Thank you.
Right. Just. They should do something. I felt like you had.
Well, no, I mean, I was listening to see if I could help address this on the legal side, because I used to be the legal director for our domestic violence program in Chittenden County. And a lot of what you might do at the police station or initially to get a relief from abuse order in court is confidential So it just tracks with, essentially, not forcing someone to have documentation that goes beyond their day in court around this, which may or may not come, but, otherwise you'd be trying to pull police files and things that, most employers don't really even want to do to get this kind of evidence.
Yeah, that's exactly right. And I would also note that these kinds of protections, both protections from adverse employment impacts, protections to access safe leave, sometimes these are needed very immediately. And so
Before legal things
Exactly.
proceed.
it is a matter of true safety that a survivor can relocate, and they won't be able to show up to their job the next day. And so we want to make sure that survivors have access to those immediate protections exactly when they need them.
Anything further? Okay, Charlie, thank you very much.
Thank you very much.
And Sophie, we will welcome you. Working away there. Answer the question, I'm sure.
So draft 1.1
One
has been
point,
superseded by 1.2.
yeah, let's just look at 1.2. Sorry, we,
Turn the ball over.
yeah, I know, that's the ball that you're following. And 1.2 is now posted.
It is now posted.
Great, terrific. So people online can follow. Welcome, Sophie.
My name is Sophie Zadatny for the Office of Legislative Counsel. Just checking here on sharing. So one quick question. It's about pilot salary. I did a quick AI check. Pilot's hourly rate is based on seniority, but annual pilots are paid on an hourly system. Although annual earnings are presented as a salary.
Oh, interesting. Well, because they work by hours, sort of like lawyers. I mean, they clock in. Hence all the delayed flights we have because the pilot is timed out.
Right.
I mean,
I wouldn't blame the pilot.
no, I'm not blaming the pilots. I'm just saying we have all experienced this. But it's not unlike other, and so that must be true for flight attendants as well.
So, again, just to reflect back on what was discussed earlier, so the amendment is an amendment to S230, so it doesn't repeat the language that was in 230 around the flexible work arrangements. I can put that up if you want, but otherwise I was planning just to go through the proposed amendment. So again, essentially this is adding in 21 VSA 471, adding section 2. This is the language that would add to the Vermont Parental Family Leave Act, the full-time teachers as defined in 29 CFR. So again, it's as you've already heard last session, this committee added in the airline flight crew employees that then it was in 461 that became passed into law. And so the request here is that if you qualify as a full-time teacher under federal law for the Federal Family Medical Leave Act, then you should also be deemed to qualify as an employee under the Parental Family Leave Act in Vermont. And I have those definitions if that would be helpful to review. If anyone wants to review them.
We have, if people would like to see it. Okay. I guess while we're waiting, I would be curious how many other jobs how many other jobs there are that are aligned with that are going to come asking every year, because it does strike me that would be great. Just do a whole group of them. Yeah.
Yeah, I don't know off the top of my head. I could look that up for you.
Well, one of the questions is, as you look at the statute, you see the first section, airline flight crews, this is section 825.801, and the full-time teachers are in same 825. 110.
There's a lot of other pieces in there, because that's the family medical leave act. There's a lot of regulations around it.
Okay, why don't you show us what the feds are and what we're gonna try and align ourselves with?
Right, so C3, this is the language here. If an employee is maintained on the payroll, so this is the definition that's being used here that would bring in the teachers. And then it has the definition of full-time teacher.
So this is federal law definition of full-time teacher.
Just 102. Oops. That's the mouse. Have the language separately printed out, which would have been easier, I think, at this point. And so this probably gives you a flavor for all the different sections that are in here.
And the back
Here
of
we go.
the federal law.
Yeah, so a teacher, it's the definition, instructional capacity by an educational agency or school. Includes athletic coaches, driving instructors, special education assistants. It does not include teachers, assistants, or aides. Cafeteria workers, counselors, psychologists, bus drivers. This would bring those folks in under coverage under the parental family, but
So Vermont has to adopt federal law. Federal law doesn't just hang there and everybody could just use
also,
federal law.
yeah, so right now the teachers and the airline crew are covered by the Family Medical Leave Act at the federal level. And the FMLA generally is, sets a floor, and then Vermont's Parental Family Leave Act generally is more generous than the FMLA in almost all respects, not every respect, but most respects. So this would just give to the airline crews and teachers that added benefit that comes under the Parental Family Leave Act, because we have more expansive definitions of things. Just back to what was done in H461 last session, more expansive definition of family members, etc.
Right.
In addition to safe leave, I mean, all those bereavement leave, we had a lot of other things that were added into Vermont's law. So then,
So the reason to do this is that our paid family leave act is more generous. People would like to take advantage of it. They're entitled to it for federal law, and we just need to align it. Okay,
Question
Yeah.
that I have is in terms of the federal law that mentions teachers, mentions airline crew. Can you give us some flavor of who else is mentioned?
I'll
That's going into
look
this,
that
so
up.
we can
okay,
get
that's our
there.
next
yeah, I
step.
don't want to go through all the regulations painfully right now, but I'll have a look and see. I think it tends to be individuals that you would just have a full-time job, like an airline pilot or a teacher. They just don't work the regular sort of hours and the regular number of weeks. I don't know how many other professions are like that, but I will double check and see if there are other ones.
Yeah, yes.
Whenever we talk about paid leave, I want to know how our voluntary program.
Yeah, part of why I answered him.
Yeah.
So we will ask about our voluntary program and how, I don't know what the numbers it has at the moment. And if we go forward with it, we will have the AG's office in, we will have,
Do they know?
Beth, I don't know who runs because that's outsourced, so we'll find out from Beth's office. Yeah, we'll
And,
find
and
out.
again, just to be clear, under the parental family leave, that is unpaid leave.
That is, right.
Right, so that's what this.
But let's get a notion of how many have enrolled, how it's doing. I have no idea. We haven't not gotten that in Senate government. Yeah.
So that was my question I was gonna follow. So is any of this like paid family medical leave, all unpaid? What we
This
just-
is all, we call it the Paid Family Leave Act because they're,
Parental family leave act.
right.
I thought the voluntary program was still a voluntary insurance policy that provided paid.
This would be earned sick leave is a separate.
I don't think it was earned sick leave. It was the governor's voluntary paid leave.
It's not a law. It's just voluntary.
Right, but that's paid. So I'd like to know, that's what I'd like to know, how that's going.
Yeah, we'll find out.
Okay, It is
Right.
paid, that's all.
To crystallize this point, the language we're considering here would only align the non-paid family medical leave that Vermont passed.
Right, so you can't lose your job, you can't, you,
Essentially job reinstatement.
it's job protection.
You maintain a health insurance, you pay your premium, but you get to keep the health insurance and stuff while you're out. And it's up to 12 weeks in a 12 months period.
Just a reminder, it's, Act 39, no, Act 32,
At 32,
and it was last year's,
age 461.
which is right there on the wall. Any other questions or concerns? I tend to be sympathetic to wanting to align with law that exists elsewhere and bring us Vermonters into being able to take advantage of the same sadly unpaid benefits, but the same benefits as they're entitled to under federal law.
So the second section, what this is seeking to do is taking the language that was passed around safely in Act 32, page 461, and adding that to the Fair Employment Practices Act. So that's a separate part of Vermont law, and that's generally the anti-discrimination law that we have. And there's a whole list of protected categories under that law. Let's see if I can. Should be there, just so you know what's looking at.
And safe leave was a piece of 461, yes.
Yes, yes. So the Fair Employment Practices Act, so there are all these protected categories. So it's an unlawful employment practice, and it lists out all the different unlawful practices. But the protected categories are race, color, religion, national origin, sex, sexual orientation, gender identity, ancestry, place of birth, age, crime victim status, or physical or mental condition. And so what this amendment is seeking to do is define that term crime victim status to include the victims of domestic violence, stalking, and sexual assault. So just to provide sort of the context for this.
Yeah, Thomas.
So I see in this language, except for a bona fide, occupation qualification requires. The self-attestation question earlier, is there precedent in current law that to qualify for any of these things, that people could just self-attest to the things, or is there?
So what the way this would work is that if you believe you've been discriminated against, and again, there's a whole variety of prohibited actions here, you would argue that, you fall into a protected status, you're in a protected category. I'm being discriminated against on the basis of my race or my religion or sexual orientation. And one of the categories that currently exists is crime victim status. And so what's being proposed is transferring the language that defines the crime victim status provision under the Parental and Family Leave Act into this statute. And so under the Parental Family Leave Act, if you were seeking unpaid leave because you're the victim of domestic violence, there are a list of kind of documentation that you can provide your employer to say, I need the leave because of, I'm a survivor of domestic violence. And then the list of documentation includes the self-attestation.
So it already exists.
It exists under the Parental and Family Leave Act.
And what we're asking to do is expand it very modestly to include.
So really all this is doing is just changing, or not changing, but adding to the definition of the crimes.
Crime victim.
Yeah.
And adding victims of domestic violence, because you have all other crime victims able to do this as well.
Right.
So are other crime victims able to just to amplify Thomas's question, are other crime victims able to attest to this until they have their moment in court? Or
so this is the definition.
Because I think Charlie's point is well taken. If you have the immediate need, the need may be immediate for an employee if it takes place at work or whatever. It doesn't matter where it takes place. But are other crime victims afforded the same opportunity?
This is the current definition of a crime victim that's under the Fair Employment Practices Act.
Beginning at on the top, page 2.
Right. So subsection 15. And it goes through who can be considered a crime victim, and with reference to other titles. So what this is proposing to do here, so you were asking, so here a victim is defined in 13 VSA 5301, provided the victim is identified as a crime victim in an affidavit filed by a law enforcement official with the prosecuting attorney competent state or federal jurisdiction. And then that shall include the victim's child, etc. And then this is what's proposed here is to add in to the definition of crime victim status, a person who is a survivor of domestic violence, sexual assault, or stalking, and who has supporting documentation from any one of the following sources. And then this is where the language is carried over from the Parental Family Leave Act of the kind of documentation. And then it does include that little ruminant number 4, the self-attestation piece. The others are, court orders, participating in a program,
Right.
etc.
And supporting documentation.
Right.
So I can re-articulate Chair's question. The categories which are above this, can they provide self-attestation? Or are we creating a kind of unique category for sexual?
Domestic violence.
I think it's different with sexual violence. And there may be.
Can you go back up just a little bit?
Sure.
Use orders, stalking, sexual assault, vulnerable adults. Can't self-attestation. That's
Right. Right. They've obtained it. They all have obtained a relief and abuse order, obtained an order, obtained an order,
Yeah, right. Okay.
or an affidavit.
And I think there is a difference with domestic and sexual assault, and I think Charlie's touched on it. Is there anything else, Charlie, or Sophie, you want to add? You stay there, so.
I would
I
note
mean,
that
just as we consider these victims different from crime victims, these are also crime victims, but sort of with additional layer.
Yes, I would say that the goal of this language is to align documentation requirements with safe leave. And so like that is the purpose that we are bringing into this, rather than creating a different kind of category for domestic and sexual violence survivors. Because what we certainly wouldn't want is for a survivor to access their legally authorized safe leave and then be able to lose their job because they did that. And so that is why the alignment of documentation standards is important. Of course, we would support victims of crime having access to protections that are not domestic and sexual violence survivors in ways that are acceptable to them. But the kind of matter in front of the committee here is aligning documentation standards.
I appreciate that, and I think everybody appreciates that up until Romanet 4. And so if we, and I think, I'm an expert on this, and I don't know how that opens up if we open that for all crime victims to be able to self-attest. I think that would be a challenge.
And I feel very comfortable with the language as it's drafted here as a step forward.
Even if we struck Romanet 4.
I think that it is important for that language for self-attestation to be accessible to survivors of domestic violence, sexual assault, and stalking, because that's the documentation requirements currently to access unpaid job protected safe leave.
Got it. So this aligns with the Safe Leave Act.
Correct.
And this we have already included as victims of domestic and sexual violence to be able to access through self-attestation. So we've already made a choice on this. The legislature has, and this committee has, in Act 32.
Yes.
That's what you're saying.
Well said.
Does that mean that, let's take the hypothetical situation that a person simply makes this up, that nothing occurred. The person is using it as an excuse to take time off. Is that possible?
I'm sure that there are checks within all of these statutes and that the civil rights unit of the Attorney General's office might be able
Yeah.
to speak more to how those play out in practice. But, you know, we know that survivors are accessing safety through these laws. And it's important that they have those protections.
Well, I guess the question is that last part of the claim, it says, for which no further corroboration shall be required unless otherwise mandated by law. And I'm trying to understand what that means. In other words, could a person make up an accusation in order to get, you know, some perceived benefit from it? And no, they can't even investigate it.
I think the intent of that language is that only self-attestation is needed. So if you are meeting the statutory definitions of domestic violence, sexual assault, or stalking, that harm is articulated in your self-attestation. Your employer couldn't then say, no, I reject your self-attestation. I need a police report in addition to your self-attestation for you to access this protection. So that's the purpose of
Well,
that
I guess
language
my
there.
question is, let's say a person wrongly makes up an accusation in order to take time off to go on vacation to Miami. Does it mean that nobody can question it?
I have never heard of a situation like that happening in Vermont. What I would note is that the vast majority of domestic violence, sexual assault, and stalking survivors never report the
Yes.
crimes that were committed against them to law enforcement. And so, you know, the reason why this committee and the Vermont legislature passed safely with this self-attestation language is so that vast majority of survivors can still seek their immediate safety needs. And I would say that the same exact principle applies to this law. The self-attestation language is already in our Safe Leave law. It was language that was passed by this body last year. So this is simply aligning documentation requirements between existing law and the Fair Employment Practices
What I'm
Act.
really asking is, suppose there is in fact evidence that a person has made up a claim in order to get some perceived benefit such as time off. Does that say that nobody can question even if they have evidence?
I would just say, I mean, an employer could deny if the employer had reason to believe that there was no valid basis, the employer could take whatever action they were planning on taking. And then if the employee says, well, no, I mean, I fall into this category, then, and they file a lawsuit or a complaint over it, then there's going to be an investigation into the merits of that, and that would, it would get pursued that way.
I think they're raising
Should be a
pursue
fact
something that
finding.
is not, that has been falsely claimed. However,
I guess
this
that's
does,
what I'd like to know is what are the ways that an employer can.
we should discuss it. We'll get AG's office into this discussion. Because I think no one's gonna, I can't imagine anyone doing that. And second, you would have, I mean, to do this, you have to bare your soul here with your employer. I doubt, I mean, it's,
I
likely
certainly
this
don't
would be
think
made
there'd
up.
be an avalanche of these kinds of things.
Yeah,
I think that would be
I
a
don't
very
even think
rare
you're
incident.
gonna want.
But just my simple question is there any way that where there is a false claim that an employer is aware is false and perhaps has evidence of the falsity of it, what does the employer do? Does
if it's false, what's the avenue of recourse for the employer?
when you have a
employer-
statement like that for which no corroboration shall be required? We've said by law, so you know what's the how can their evidence be used?
Right.
So
Excluded it.
Keisha had her thought, and then we will, we're gonna, we will then have the AG's office in for further discussion.
I mean, so I have many thoughts, starting with, you know, to achieve safety, victims have to do a lot and survivors have to do a lot. That can look like leaving work to find new housing arrangements, or it could look like going to stay with family in Florida while divorce paperwork is served to somebody. Because a piece of paper does not protect you
Right.
if you're in danger.
Right.
And you're afraid.
And
So-
the dangers at work, that's even
So
more challenging.
that would be my next point is that we could also have the network come back and talk about how employers are usually really valuable partners in helping someone achieve safety, more so on the side of the perpetrator or the alleged assailant, the abuser. It is shown that the person they are most likely to listen to if they are on the job harassing a partner, leaving work to go commit some type of violence or harassment against somebody, the person they're most likely to listen to is their employer, saying, you have to stop this. This is not okay behavior. It's nice, it's just good employment practice, good HR practice. If a victim can talk to someone in their place of employment, because that person could show up and endanger other people. When we see domestic violence related homicides, and the ones that have been the most gruesome in Vermont, it has often been someone showing up to abuse or threaten or kill a partner, and other people become collateral damage. So it's beneficial for all of us if someone can be open about this situation, but it's also beneficial for all of us if that person does what they can to get safety from someone who is abusing them. I will say, on the whole other side of this, when we talk about doing our own state paid leave program, I think the reason we've been tripped up on this, and I agree with Jane Kitchell and Bobby Starr, I missed them for this reason, is because we would have had to set up an apparatus that's more expensive to make sure someone deserves leave than just give everyone some paid leave to take care of a number of crises they could face, a flood, a mental health crisis. So I hate this conversation.
Yeah.
Usually because everyone deserves the dignity of paid time to take care of
It's a separate issue, and I don't
their
get that.
matters. So
I would boldly propose, given we're almost at 10 o'clock, that we continue this conversation with the additional witnesses people would like. We'll get the AG's office in, we'll get HR in to update us on the volunteer paid leave. And any additional data we can get from the network would be great. Colin and Rebecca, if there's anything additional for you, we will take this up again and make a decision. And when we take it up again. And thank you very much, everybody. We are going to shift to our next labor issue, which is F. Great. Okay, come on back.
Yeah.
We're going to shift to 173 to our workers' comp bill. As I mentioned, the House is moving on the second half of S-173, which is the Labor Relations Board work and the additional staff, the mediator, you'll recall that whole piece. So the House is moving on that. So we're going to strip that from this bill. And we're going to move in, we're going to just discuss the workers' comp bill, sorry. So to that end, we are going to begin. We're going to begin with Kelly. If Kelly could set the table. Sure. Welcome back, Kelly Massicott, to our committee. It's good to have you. Oh my God. And you're it must be workers' comp day. I know. Great. It's good to have you all. Kelly, if you would just remind us where we are with this.
Exactly.
And what we're addressing,
20,000
and we're now
view.
just focusing on workers' comp in this bill.
Yes.
So it's 173. If people pull it up, they should have it from last week, from their file.
Thank you again, Kelly Massicott, on behalf of the Vermont Association for Justice. I'm a workers' comp attorney representing injured workers here in Montpelier, a partner at Bigham Fox Skinner. Again, we're talking about work injuries here in Vermont, and specifically vocational rehabilitation for injured workers. It's one of 4 benefits in the workers' comp system. Very few injured workers are actually entitled to this benefit, vocational rehabilitation. It's only when a work injury leaves an injured worker unable, after full recovery, recovering as best as they can after a work injury. If the work injury leaves them unable because of restrictions and limitations from the work injury, they're unable to get back to earning their pre-injury wage. It's an average weekly wage is what we look at. So we do look at their education and their skills, not just the job they were doing, but their education skills in case they have other ones that could bring them back to that pre-injury wage.
So just before you go on, when you say very few workers actually end up qualifying for this benefit.
You're gonna ask me the,
Okay,
I don't know, Dirk might know.
Dirk might know how many, of the total number of workers' comp claims, how many actually qualify for, both rehab?
Thank you, Madam Chair. Dirk Anderson, Department of Labor. I do have some numbers. I can tell you now, or you can wait until it's my turn.
Tell us then.
Okay. So
So we
roughly,
know in context.
roughly on an annual basis, 2,500 Vermonters receive indemnity benefits. So that means they're out of work for more than 4 days and they are entitled to wage replacement benefits. Roughly 10% of those, or 250, 300 maybe, are out the requisite 90 days. I mean, you don't have to be out 90 days to qualify for both rehab, but that is what triggers the carrier's responsibility to notify the injured worker.
Got it.
So that's kind of the subset of the population.
Great. So that, I think that's all. David.
How many require mediation? That's what the bill's about, is mediation. Right.
Different part of the bill. I'm not here to speak about.
Yeah, the mediation's actually the last page, which is the workers' comp.
Mediation is the labor relations board, which has been, we're striking from this. Because the House is we're sending a bill out. So we don't need to do double work. It's the whole hope of our very short time in this building.
And I will say what the statistics Dirk was just speaking about, 10% of the people who are out more than 90 days, or excuse me, 10% of the people who receive indemnity benefits. So people who are out of work for more than 4 days because of a work injury are flagged by the filter we have to see if they're interested in being assessed for this benefit, which doesn't mean that they're actually entitled to the benefit.
Right.
So it's even
upset.
So if we even take the number of work injuries, which I don't know, Dirk, do you know how many Form 1s are filed in the state in a year?
17,000.
17,000 Form 1s, meaning injuries are reported. 17,000, right? And then of that, 2,500 people are missing or getting some sort of indemnity, meaning wage replacement, because they're out of work for 4 more days. And then out of that, 10% of those are then out of work for 90 days or more, which flags the, hey, you might be screened and entitled to this benefit. And then do we know how many from that are actually entitled to the benefit?
We know.
Sorry, well,
I think
it's a very small number.
What I think is important for this committee is to understand this is a small subset.
Right. And Dirk did say something that's important that I was going to highlight, which is right now the flagging method of somebody out of work for 90 days is when there's some sort of trigger for whether it's screening, which where we're trying to get rid of in this bill,
right,
or whether it's done some other way, it's 90 days out of work. That is kind of the method of trying to capture and checking out whether these people are entitled to the benefit. It's not a perfect method. It doesn't capture everybody who might be entitled to the benefit, because again, what we're looking at is, does the work injury after the best recovery you can have leave you unable to go back to your pre-injury wage? And there's certainly situations like employers who accommodate people who never go out of work, because there are employers who continue to accommodate people after a work injury,
right,
who never go out of work.
Right.
But once they fully recover,
right,
the employer says, I'm sorry, we can't hold on to you. They're gone from that job. Right. They've never been out of work, and they wouldn't retrain. They wouldn't know it though. They don't trigger the VR form. and the person would never know that they might be entitled to this benefit. So that's just my plea that it's not a perfect system in many ways.
So we need to do a better, also maybe perhaps DOL and employers need to do a better job when in those circumstances, letting people know there are some opportunities.
I will get to the bill right here, but I will say very strongly, VR needs a major overhaul. I think Dirk would not disagree with me on that. I think the VR counselor we have to testify, Karina Dunnigan, would not disagree. I think everybody in the system would agree. There was proposed rule changes a few years ago. I was part of the group that was successful in shooting those down because I did not believe they were helpful for injured workers, but it needs a lot of work. This proposed bill helps to change in small ways things to improve the system, but there is work that needs to be done in voc rehab overall. And I would be happy to be part of it. There needs to be change.
I think actually we would be interested in entertaining a notion of how we, once we look at fixing these particular.
This small
problems,
piece, yeah.
how we can work with the department to move forward and review and maybe charge the department working with you to begin some of that work of re-envisioning what we had.
So back to
something, looking at Rowan and Dirk,
Well-
that's something we might chat about.
The last time the department introduced voc rehab rules, which Ms. Massacott helped kill.
Right.
I just admitted it.
She did.
Nobody talked to the claimant side. They weren't great for injured workers.
At that time, I was not in this position, so I wasn't familiar with those rules, but the fact that we introduced rules, I think, is an indication that there is work that could be done to make voc rehab better.
That sounds like a possible addition. Okay, great.
Back to this.
Back to 173, and what we're really looking at, just to go to David's question earlier, is section 1. We are not looking at section 2 any longer.
Correct. So this bill has 3 goals and here. So in section 1,
yeah,
the first goal, which is page 2, line 20, is to inform injured workers that they may be entitled to the benefit in the future, even if they're not entitled now.
Right.
If people don't settle their claims, and these claims don't have to settle, work injuries can sometimes get progressively worse over time, and they could be entitled to this benefit in the future. And so the bill proposes just for there to be a notification on the paperwork sent out by DOL that hopefully an injured worker might read, and it might plant a seed that someday they might be entitled to this if the work injury prevents them from earning that wage. So
And that right, Kelly, exists into it for as long as.
It's already there. It's
Right.
just informing. I know it as a claimant's attorney, but unrepresented injured workers don't know this.
Okay.
So that's kind of a no-brainer to me.
Right.
Section, let me get to the next section. So the
So
second
that's the
goal,
first act.
yes.
Ask.
The second goal is to get rid of the unnecessary step of VR screening, which right now is done by state VR counselors. In the workers' comp system, we have,
And that's in
that's all of page 3. It
Yeah.
begins, on line 5.
Yeah.
Of page 3.
3. Yeah.
Again, a very small number of injured workers are entitled to this vocational rehabilitation benefit. If somebody is entitled, it can run the gamut. It might just be help polishing a resume and interview skills. It could be something substantial. I mentioned before, it might be an associate's degree if it's a very high paid worker that can't get back to that job and they need some education. So to understand if somebody's entitled to this benefit, there's an entitlement assessment done by a VR counselor who is a private counselor that knows the rules, the VR rules, and is familiar with what the standards are. Right around the time I started practicing 20 years ago, I believe they instituted this screening process, which is done by the state VR people. These people aren't familiar with workers' comp, and it's not their fault. They're not trained in it. But the idea is that they kind of do this screening. I think the hope was to streamline and figure out who should get that entitlement assessment earlier and who should kind of hang on. It's not been successful.
Right.
And there's
So
a
we
VR counselor here who can speak about that. It's not been successful. So the ask is to get rid of this step.
Got it. And replace it with,
Just having it go to the private counselors who know what the standard is and are familiar with
okay,
it.
just go to experts in this area.
Absolutely.
That makes it.
The state VR folks, not only are they not familiar with the standards in workers' comp, but they also, there's a delay. If they screen it and they feel like it's not ready to move on for a full entitlement assessment, it gets put in for another 90 days of screening. The same counselor doesn't see it again. So it's another set of eyes. There's not familiarity. So it just, in my opinion, and the opinion of many, is that it's not been successful and we should get rid of it. And then number 3, the third goal, which is on page 4, lines 5 through 8, is basically to allow an injured worker to initiate these VR services after 90 days out of work, which again is right now the trigger, if the carrier has failed to. Now, 2 things I want to say. When I refer to VR services, this does not mean they're entitled to the benefit. It just means getting the counselor involved in assessing whether they're entitled.
This is just to assess if they're entitled.
And sometimes it's on hold because they don't have enough information and they can't decide if the person's entitled. And it sits there and they kind of suspend for months because they don't have the information to make an informed decision. So when I say initiate services, it just means getting that counselor involved. The other thing is, an injured worker right now under the law has the right to change VR counselors. The minute the carrier assigns a VR counselor, I or an unrepresented person can file what's called a VR rate and change the counselor. So it's not a big deal for us to allow an injured worker to file and choose the counselor from the outset.
Right.
Because if we're getting rid of screening and the trigger is already 90 days, if the carrier fails to do it, why not just let me or an unrepresented person do it on their own if the carrier hasn't done it? It lets us get it going faster, which means people are going to get retrained faster if they're entitled to this benefit, and they're going to get back to work faster.
We like that. We like getting back to work faster. The question I have for you is who's paying until that is assessed? Who's paying? What's the pay seed?
So the carrier is paying for wage replacement benefits while somebody is trying to recover from work, from the work injury. And they're also paying for the vocational rehabilitation counselor, private counselor, who is helping the person if they qualify.
So there's an incentive here for the carrier to support getting this all done faster.
Sure,
Sure. Back to work faster.
Sure. I mean, I told you last time, there's the cynical part of me that thinks the carriers actually like to delay the VR process because people's indemnity, their wage replacement, can't be cut off until the carrier has shown, the VR piece has been looked at. And so sometimes that's the point that it finally gets looked at, even though it should have been looked at months or sometimes years earlier. And by that time, they finally filed the form. It's so late that the person who might be entitled to voc rehab can't meaningfully use it because they can't afford to because they don't have the money to do the class. It doesn't pay living expenses. So the sooner you can get going on voc rehab and have that wage replacement while you're recovering, if you can do classes, if you can get the training. So I think carriers cynically sometimes want the squeeze, want the person to feel the squeeze and don't want them to do the plan, want them to settle it out for less money. Because then they can pay less. If the person gets it started earlier, it might cost them a bit more because they're going to use the full extent of the services. But by the way, this is against my own self-interest. I get more of a fee if the case settles. I'd rather my client actually get the VR services, folks.
I'd rather get them back to work.
Well, that's what I'm saying. Get the VR services so they can get back to work.
That is stimulating, maybe even pays more.
Pays at least as much, but pays more.
But key is to get them back to work.
By the way, side note, it's not in the bill, but the whole pays as much. A person could be injured and it's 5 years later by the time that they're trying to get back to work. We're trying to get them back to the wage they made at the time of the injury. It doesn't follow with inflation. Their compensation follows with inflation, but not the voc rehab piece. And I've always thought that needs to be corrected too.
Well, maybe we will put that into something
larger. I didn't try to put it in.
No, got it. Thank you. So
Thanks.
that's helpful.
Yeah.
The goals in this bill.
Yes.
And we are going to hear,
Karina Dunnigan is a voc rehab counselor here from Catamount Case Management. She works, she's a private voc rehab counselor, and she is here to speak to the delay and how this is a broken process with the screening.
okay,
Yeah.
great. So we'll go to Karina, then we'll go to Jamie, just to shake it up a little bit, and then we'll go to Dirk.
Thank you all.
Thanks, Kelly, thank you.
Thank
We're
you.
really great. Is that okay, Dave?
Absolutely.
Dirk, okay? You're
Fine
gonna
with
be
me.
cleanup. Karina, welcome.
Thank you.
I'm not sure you've ever been in
I
this
have never
committee.
been there. No.
So why don't we introduce ourselves and we're Senate Economic Development. David, you want to start?
Dave Weeks, representing Rutland County.
Nice to meet you, Senator.
Randy Brock, Franklin County and Northern Grand Isle.
Nice to meet you, Senator.
Allison Clarkson, Windsor District.
Tom Chittenden in the southeast areas of Chittenden.
Nice to
And
meet you.
Keisha will be joining us again shortly. Keisha is also Chittenden Southeast.
Okay.
So introduce yourself and bring us into the voc rehab room.
Okay. Well, I've got some prepared remarks here.
Right? And I would hope you would send your remarks, email them to
Yes,
Kiara as soon as possible.
certainly. Good morning, Senators. Thank you for having me. I'm Karina Dunnigan. I'm a private vocational rehab counselor and owner of Catamount Case Management, a company that provides vocational rehabilitation to injured Vermonters. My business has been in practice for over 30 years. Most of those years did occur under the previous owner, who is also my father. I'm one of 25 counselors in the state of Vermont who are certified by the Department of Labor to provide vocational rehab to injured Vermonters, injured Vermont workers, I should say. And VR is one of 4 benefits that an injured worker may be entitled to receive. In order to provide,
Did you say that one? Voc rehab is one of
it's
what?
one of 4 benefits that an injured worker may be entitled to receive. In order to provide these services to injured workers, counselors need to have a master's in counseling and specific work experience within the Vermont workers' compensation system. As you know, the VR screening was designed to cost effectively identify people who had a work injury and may need assistance returning to suitable employment. Unfortunately, it's not been effective at what it was designed to do. It doesn't do a good job of identifying injured workers who need assistance, either because the screening is not being completed in a timely manner, it's not being completed at all, it's not being completed correctly, and there's no one checking to make sure that the system is functioning properly. And there's also no remedy for when the system falls apart. Other than some injured workers' attorneys, there's no one checking, as I mentioned, to make sure that the referral is done in a timely manner, that it's done correctly. And injured workers, mostly, unless they're represented, they're not even aware that voc rehab is a benefit that might be available to them. I'd like to tell you about a real case that I have that I think illustrates the problems associated with the screening and the delays that can occur. And just to be clear, Kelly's really passionate about these issues, but this isn't one of her cases. This is an issue that is well known among attorneys across the state representing injured workers. And my client, who I'll call Sam, experienced a foot injury while employed as a stove installer. As you likely know, stove installation is extremely physically demanding. You're required to lift over 100 pounds and some of that while going up ladders. So it's really demanding. Sam had always worked in physically demanding work. He'd always had jobs on his feet, and he struggled academically when he was in school and eventually completed his GED. As a vocational rehab counselor, I can tell you that someone with this background and the academic struggles and the work history that Sam had, combined with a foot injury, which are typically really can be very challenging to recover from just because of the amount that we all use our feet. Sam is very likely going to have limited opportunities to get back to work, even if he has a good recovery, because an injury to a foot can be really limiting in what you can do. And so Sam was referred to his first screening when he reached 90 days out of work. So that was when the first screening was supposed to happen. The system was working the way it was supposed to. And as you know, the screening considers information from 3 categories: medical, employer contact, and contact with the employee. The screener reached out to Sam and his employer, and the employer indicated that they wanted him to come back to work, but they would try to accommodate him by having him avoid going up ladders. But he didn't have, bless you, he didn't have a return to work. He was still in medical treatment at that time. And Sam was hoping to get back to work at that time. The screener concluded that Sam didn't need to be referred to someone like me for a full eligibility assessment because it appeared he would be able to go back to his job eventually, and that there was no evidence to the contrary. But the screener did recommend a follow-up screening in 90 days. Now we come to the second screening, which unfortunately didn't occur until 150 days. So we see a bit of a delay there. And again, Sam was not represented. He doesn't know what he's entitled to or what may be out there for assistance for both rehab, and no one is checking to make sure this is working. So 150 days later, and it's a different screener, so it's a second person who is coming at this with new eyes. We see Sam was still in medical treatment, but he's got some more issues with his foot. It's not healing, and he's now been out of work 8 months. The screener spoke to the employer, who explained that Sam had attempted to return to work for 2 days and was taken back out of work on the 3rd day because he was in so much pain he couldn't walk. So we have information documenting that Sam had an unsuccessful return to work. He's still in medical treatment. He hasn't been released. And he's having difficulty. He's now been out of work the better part of a year. The screener determined he doesn't need to be referred to a VR counselor for an eligibility assessment. However, follow-up screening in 90 days is recommended again.
Jeez. It's an unproductive cycle here.
For sure. Now we come to the third screening, which was done roughly 90 days later by yet a third person. So again, a new person, doesn't know the case, but coming at it completely new. So since the second screening, there had been medical imaging done on Sam's foot. It showed a non-union fracture. So that's a fracture that is failing to heal, a huge problem. And now Sam has been referred for surgery. So we have confirmation that Sam has additional significant medical treatment plans. She talked to the employer. The employer said, we don't have light work. Sam needs to be at 100% before he comes back. So now we have information confirming the employer cannot accommodate anything less than 100%. We have medical information showing that Sam is struggling in his recovery and he needs surgery. And yet, still no referral to a VR counselor. Follow-up screening in 90 days, again, recommended. At some point in this process, Sam hired an attorney who was familiar with the delays that the screening process can cause. And she fought very hard to have the Department of Labor assign a VR counselor because Sam had now been out of work for 18 months with no assistance. He had lost his housing and he was living in a motel with his wife and stepson. That was where he was at when he was referred to me. So he'd been out of work 18 months and had really had huge impacts on his life because of the reduced income.
Spot here if I can.
Yeah,
So
Scott,
I'm not really familiar with the world of VR counseling and such. Who in this process should have referred him and at what point? That's the point I'm, like, I understand the story, it's all lagging, but
It's frustrating.
what was, who and where and when was the step missed?
And how is this bill, how are the recommendations gonna improve this?
Yes, so the currently, the adjuster can refer an injured worker,
Buster works for him.
the insurance company, the workers' comp insurance company. Instead of referring for a screening at 90 days, they can just refer to someone like me, a VR counselor, who would then just do the entitlement assessment right away.
So you're qualified to do the entitled
Yes.
assessment and prepare somebody for different work if necessary.
Yes. Yep. So what should have happened is we have a little breakdown of the system in multiple ways, but what should have happened is that first screening that Sam had, he should have been referred to someone like me who did assess his eligibility for vocational rehabilitation. But instead, they found that he didn't need to be referred, and that's an incorrect conclusion based on the information that that 3 screeners had, in my opinion.
So finally, after 18 months of being out of work, he is referred to a VR counselor,
Yes,
to you, I guess.
yes, he was referred to me. I found him eligible immediately. All the information was there. He can't go back to his job or any of his jobs he previously did earning the same money because of serious foot injury. He's now got restrictions.
And he's had his surgery and
Correct.
healing.
Yeah, so by the time I came in to work with him, it had been 18 months since state of injury. He was now basically done with his recovery, which is a huge problem because that means wage replacement is ending because it's tied to the medical treatment.
Right.
And so he started working with me. He now can't really take advantage of vocational rehab because he needs an income as soon as possible. He's no longer getting the wage replacement that he was getting when he was still in medical treatment. So the delay can impact somebody's return to suitable work, meaning that as close as possible to what they were earning at the time of injury and physically appropriate. The delay can impact that very, very much and in not a helpful thing. Let's just put it that way. So just to conclude and to summarize, the screening process failed to identify Sam's need for vocational rehab for the better part of a year. That's a time that he could have been working with someone like me to create a return to work plan. And a lot can be accomplished in a year.
Yeah.
To get him back to suitable work. Because there was such a delay in Sam getting vocational rehab, by the time I started working with him, he could not utilize the service to the full extent that he was entitled to. So I determined that he was entitled to retraining, to go back into a different line of work that would not have him on his feet all day and not lifting 100+ stoves. Because he has no income coming in by the time I start working with him, he can't do training. He doesn't have the time. He needs to find a job ASAP. And that puts pressure on him to accept a lower wage, basically whatever he can get, a lower wage and a job that may be putting him at risk.
So I have a question here, and then David, why, I would have thought, given this sort of lags, that Sam could have appealed to the Department of Labor for additional flexibility and an opportunity for training for this, given how long, and if he had a lawyer, how failed the screening, how the screening process just really didn't serve him, and how he lost that opportunity in their delays. And if there was a good lawyer here, I would have thought they would have been appealing back to DOL. Yeah,
Yeah, maybe I can let Kelly.
yeah,
speak on
Kelly
that a
looked like
little
she was
bit
ready to
more,
answer
but-
that.
So the wage replacement are not tied to the voc rehab. So Karina's right. He's entitled to retraining, but if the guy's gonna work, he can't do the retraining and work necessarily at
We
the
can't
same
take
time.
the
And what Karina said something very important, but it trailed off, which is he was forced to get his doctor to release him. He asked his doctor, release me for this work. I gotta get this job. And it's work that's probably very likely to lead to re-injury because he's working on his feet again. But he's gotta do the work because he's gotta support his family.
Right.
So he is doing work that his doctor said he can do. But it's a little bit, it's not a great situation, right? It's not a great situation. Honestly, wage replacement should be more tied to voc rehab, in my opinion, just because of this problem.
Another piece to work on, which we may ask.
Yes.
Okay. So it sounds like it's safe to say he's now back at work doing work that may just exacerbate the initial injury.
Yes, that was my kind of concluding summary, is that he's had to accept a job that's below his wage and that has him on his feet all day. And we all agree that that's not the best situation for his foot.
David, you had a
No,
question.
mine was similar, my question was similar.
We must work together on some of this. Well, that's discouraging. And then I hate to ask the other obvious question, which is, I mean, just to complete this story, which is how old a person is this? Because how long is a work life affected by this?
Yeah, so he was 45 when he was injured.
So another 20 years of work.
Yeah.
Yeah, that's tough, sort of halfway through his work career.
Yes. Yeah, this is an example of how the delay in the screening being completed correctly, or the delay in getting to a VR counselor can really impact somebody's return to work and their wages for the rest of their life, their health for the rest of their life.
Yeah.
So I support what this bill proposes to do, which is remove the screening. And that's going to improve the timeliness that injured workers can get back to work. And I really appreciate you taking the time to listen and assist injured workers. Thank you.
Thank you. That was terrific. Any other questions for Karina?
Thank you.
That was an illustration of pictures worth 1,000 words. Thank you very much.
Thank you.
Jamie. It was good to see you last night.
Thanks for having me this morning. Jamie Pean with Kramer Piper, Legacy and Kramer, on behalf of the American Property Casualty Insurance Association. APCIA is a national trade association of over 1,000 members. So 100 of whom write P&C line, all lines in Vermont, including workers' comp. Collectively, they probably write a little more than 2/3 of them. This is the
You do 2/3 of the workers' comp claims.
2/3 of all P&C lines. And workers' comp is part of it. Comp is a different property category. Yeah. APCI has a shared goal of helping injured workers return to work, effective voc rehab can accomplish that. However, the amendments, we believe, remove appropriate guardrails and introduce costs. If they're unnecessary, and therefore I would ask you not to move forward. Let me first speak to some of the current market trends that we're seeing, which will help provide a little bit of context for our position. As you may know, workers' comp rate making is kind of a different process, at least compared to other lines of insurance. There's sort of forward projections, and then there's a true up at the end. Projections might look at, for example, loss trends, which is primary component in a workers' comp premium. And those loss trends cover indemnity and medical costs. And so there's an entity called the National Council of Competency. I always forget the acronym. They help gather information and data, and they give the Department of Financial Regulation every year projected loss costs for that for workers' comp. And so
Starting in 2017, Vermont has seen a notable trend in these costs for the voluntary market, which is the open and competitive, the other market, of course, being the scientists. Starting in 2017, there's a 7.9% decrease in loss costs. In 2018, 3 points. The next year, 5.1% decrease. In 2020, 11.6% decrease. 2021, 5.5% decrease. 2022, 4.9% decrease. 2023, 6.7% decrease. 24 is an anomaly, it was flat. 25 is 7.4% decrease. While this is good news, and the reduction is really a reflection of focus DFR, Department of Financial Regulation, was put on some particularly high risk sectors. Vermont workers' comp premiums are still above average nationally. However, another translation of this downward trend is that the system is working as intended, at least with respect to loss costs and trying to bring them down. Turning to the bill, this removes the ability entirely, as you've heard, to have a screening process, which we think is an effective starting process. That screening process helps determine whether a full assessment is appropriate with mandatory referrals to the Blood Rehab Council thereafter. Moreover, it hasn't received too much attention. On page 3, line 5, it's deleting the cost effective state, which we think is an important lens to keep in place so that, for example, whether it's an employer or an insurer, at least has the ability to say, to use that as a lens and argue.
Is that B?
That is line 5, page 5.
Okay. Oh, I see. Good. Right.
You know, it's a little bit of a deja vu for me on this bill. You may recall last year's bill, there was an issue related to timely payment of funds, penalties and fees, which we assessed a failure to do so. And at the time, there was a question of whether or not the data would support making a policy change. Kind of feel similar in this regard, because I hear from APCIA members, they don't see a problem in the screening process or the Blood Rehab process, at least from their perspective and their folks on the ground. They haven't seen any sort of systemic problem that would, for example, substantiate removing the screening process in its entirety. On the contrary, it may be that, as I mentioned before, the system is working as intended and claimants are appropriately screened for a full assessment. I'll also add, as you've heard, that the injured worker has a right to change both rehab councils. They have that right now.
Right.
There's also a process that the injured worker can invoke, or the insurer or any party to the particular issue can invoke, and that's administered through the Department of Labor. First is, and the rules speak this out, the DOL rules speak to this. First is, DOL, of course, encourages the party to seek a resolution on it before they come to them. The second is asking the department for a conference for discussion, mediation, and resolution. And the last would be a request that the disputed issue be addressed at a formal hearing. So there are mechanisms in place to address maybe perhaps some of what we've heard this morning, but in general, for these types of claims, if there is a process at the screening level. So again, I feel in APCIA, in the absence of some data to sort of substantiate such a change. Perhaps it's more if there's a problem within the current screening process, maybe we target solutions there. If the timing needs to be looked at, if the questions asked need to be revisited or somewhat addressed, maybe that's the better place to look rather than drawing out the entire process in this entire entity.
Thank you. I have a question for you. Costs to whom? I mean, how are you assessing those costs? Are you talking about just costs to the insurance company?
It's costs into the system, which will
people's lives and the cost to their families and the cost in time.
Well, this is, of course, on behalf of insurance companies.
I know, I'm just
working with employers and looking through that lens. And yes, we believe this will add cost into the system that will be borne by the system, including insurance.
But it's borne by the system with the loss of the worker not working too. I mean, so the quicker workers get back to work, that's a plus for.
As I say, it's a shared goal that insurers have.
Okay.
To help the injured worker get back to work.
Right. So you see an initial screening, you see mediation. It sounds like worker. I mean, just from a high level, it just seems that perhaps injured workers are not fully aware of all the opportunities that lie before them with these sustained injuries and ongoing injuries. And that, I mean, you talk about mediation, you talk about other things that the department could step in and help with, but it doesn't sound like
Well, again,
enough people are asking for.
sure, and I'm not intimate with the questions asked at the screening process, but I could potentially be a component to be added to this already. Here are your options.
Great.
If they're denied full assessment, I just have to assume that they're given something to consider your options after getting this.
Given our time frame, because we have to leave here in about, it takes us 7 minutes probably to get over it today. I would suggest we hear from Dirk, and then we will come back to this and clarify. But thank you, Jamie. That was very helpful. Did you have a question, Jamie? Okay.
I mean, you cast a great net in terms of hearing from interested parties, but employers is a one focus.
Yeah, no, and ABC would be good.
Yep.
Great,
Appreciate it.
thanks.
Thank you.
No, really appreciate it. Dirk, welcome.
Thank you, Madam Chair. Dirk Anderson, with the Department of Labor. I'm the Director of Workers' Compensation and Safety. Have been in that role for a little over 3 years now. I've been with the department, for like 24 years.
A while.
Which is
Because
a
in my 22 years, you have always been one of the faces. Yeah, well.
Thank you.
Yeah, well,
I think that's good. Maybe it shows a lack of ambition.
No,
But,
or maybe that could say the same thing about me.
So I know you've got limited time, so
Well, just only today.
I will start by saying the department is generally supportive of this bill. And the reason for that is this. The initial screening has been in place since about when I started, so over 20 years. You've heard what the claimant bar thinks of it. The general consensus among my staff is that it is not particularly helpful either. And my main reason for supporting the removal of the initial screening is the delay, because the carrier has to file a form with us. We have to refer it to hireability over at Dale. The Dale screener has to screen it. They're supposed to do it in, I believe, 10 days. That doesn't always happen. And the majority of the initial screenings results in an approval, like, yes, this person may be entitled to services. So it's just a delay in the process, doesn't really accomplish much, which I think is what Ms. Massica testified to. The people at Hireability, we have spoken with them. They don't particularly like doing this. You certainly welcome.
Oh, hireability of the screeners?
Yes.
Okay, I missed that piece. Okay.
Certainly welcome to have them in here to talk about it.
Yeah.
And maybe to address what Jamie said, about the necessity for some sort of screening of the people who are eventually injured workers who eventually do get an entitlement assessment from a VR counselor. Not all of those result in approved plans, because the third step that we haven't talked about yet is the VR counselor needs to submit a VR plan to the department. One of our employees, Tracy Smith, reviews it to make sure it is reasonable. And a subset of all entitlements result in actual approved plans. So there's still some gatekeeping by the department to make sure that people aren't just getting VR for the sake of getting it, whether they need it or not.
Got it. So that's already built into the system.
Yes.
I think that adds a level of. Yeah.
So that's about it.
I
do support it with.
And okay, because I'm going to ask my other question.
Okay, I just wanted to comment on the first change at the bottom of page 2, line 20 and 21. The right to request folk rehab services in the future.
Yeah.
The department does already notify injured workers on the form that goes out to them that If you decline VR, I'm reading the form, injured workers who decline VR services may request them at a later date by writing to the Department of Labor and providing their reasons why they should receive services. Now, I think Kelly would probably like to see more robust language
Maybe
there.
it could be in both.
We could do that. I don't think that would require legislation.
My guess is we can improve this,
Yes.
but it's good to know that at least it's there and all we need to do is work on improving or underscoring or bolding or whatever. Great. Okay. Or something else. Thank you.
That's it in a nutshell.
Well, thank you. Much appreciated. Committee, any questions for Dirk? So I think the second question is if we work on this and get this to a place where we're happy with it. I hear that we might hear from ABC and from Hireability and from a couple other, we've got some other ideas of additional people we might hear from, and somebody, actually a person who has gone through other than Sam. I think Sam's story was well illustrated. Thank you very much, Karina. The other question is, of course, the bigger question that Kelly and Karina raised, which is maybe the whole thing needs to be looked at and reviewed. And might we think about charging DOL and interested stakeholders to come back to us next session, next biennium, with a proposal on how we continue to improve book rehab, because this committee is very interested in getting workers back to work, doing work that gives them pleasure, that's fulfilling, that's productive, that furthers their lives and the work in Vermont. So I think we all have interest in having a system that's more successful, it sounds. So would you think about that? And perhaps we can engage with all of us and Mistress of that name to craft some kind of proposal. Okay, to consider.
I would consider that.
Okay, great. Let's work on that offline. Unless there are other questions, committee, we are going to take your badges and we're going over, we're going to flip to economic development. We're going to hear from the outdoor rec business on our economic development bill. They're going to be addressing the impact, the economic impact study they've asked for, and we're going to be hearing, we're going to shift to economic development for an hour. So take your badges. We're up on the second floor in room 270. And Kara is going to run that meeting. And Dirk and Rowan and Helen and Karina, thanks very much.
Thank you.
And Sophie, of course, always.
Okay.
Oh, let's go offline.